Welcome everybody to the welcome to September, to the September 1st edition of Legal Tech Week, the show where we talk about the week's stories in legal tech and innovation. And for anybody here thinking they're joining our 10th anniversary show, because we did, our 100th show, not our 10th anniversary show. Uh, that would be a long time. Our 100th show, which we talked about last week, that might be this week. Well, it's not this week. So come back September 15th. We are going to have a gala Friday afternoon, 100th episode show with everybody who has ever been a panelist on this show joining in. I don't know how we'll all have time to say anything, but we'll make it work, and hopefully we'll all be wearing party hats and make it worth your time. But as for this week, we are here to talk about the stories from this week. We've got a couple of eDiscovery stories, and so invited back our resident eDiscovery expert here, Doug Austin, to join us, and a couple of other stories from the world of legal tech. So let's just start as we always do with our introductions. And Doug, you want to kick it off?
Sure. I'm Doug Austin, editor of eDiscovery Today, with his blog about 3.5 years old. I've been daily blogging for 13 years, which, like I said last time, would be impressive in most groups, but not so much in this one. But glad to be here, as always.
We're always happy to have you here. And Niki Black.
My name's Niki Black. I am the head of SME and external education at Affinipay, which is the parent company for my case and LawPay. I write legal tech columns for ABA Journal, Above the Law, Daily Record, and other outlets, and I also oversee and write our the My Case and LawPay benchmark reports and annual legal industry report. I'm happy to be here.
All right, and Gina Grady.
Hi, I'm Gina Grady. I write the Dewey B Strategic blog, which covers mostly research, knowledge management, but other things that come up and interest me. And I also write a monthly column for Legal Tech Hub.
And Victor Lee.
Hi, everyone. Sorry. My name is Victor Lee. I am assistant managing editor of the ABA Journal, covering business technology. I don't know what's wrong with me today. Business technology and law.
And last but not least, Patrice.
Joe Patrice, senior editor from Above the Law and the Thinking Like a Lawyer podcast, and excited to take a break from my favorite sports weekend of the year to join and talk about some legal tech.
All right. Well, so I guess the biggest sort of news story of the week from the legal tech world had to have been the news that the eDiscovery company Reveal had done a double acquisition of two other eDiscovery companies of Logikcull and IPRO in a deal maybe valued at like $1 billion, although the reporting around all of that has been really inconsistent. I don't know. I'd love to hear some of your perspectives on it, but clearly a very big deal.
Could you say that they have not yet revealed all the details of the?
Good. I don't know if you want to.
Yeah. I can't even think of a good comeback to that, but yeah, that we could say that. But very interesting deal. I mean, on the valuation of it, it's just been interesting because the press statement that they put out said that the value of the deal was $1 billion, or words to that effect. But then I have since seen other reports that say the total investment in Reveal by K1, is it K1 that did the deal, is $1 billion total for everything, and they'd already put 200 million in a couple of years ago, and then I've seen that another one saying that the total of all the acquisitions they've done is at $1 billion. So I'm really not sure what this deal is worth, but it's a big deal. If anybody has insights on that, but Doug, I just wonder, obviously you're probably more in tune with the eDiscovery world than any of us on this panel. I wonder what you think of this.
Well, this is, I think, I don't know, something like the fifth or sixth companies that Reveal has acquired in the last couple of years. They acquired BrainSpace. They acquired a partner of mine earlier this year, Legal. Now, and acquiring two companies at once, pretty wild. I understand why they did it. Both companies have great tech. Bob, as you pointed out on your blog, IPRO is one of the few companies that really truly have end-to-end eDiscovery because they have an InfoGov solution. They, of course, they have Trial Director. So obviously that helps them check that box or all those boxes. And Logikcull has been a great small and medium-sized firm, do-it-yourself kind of platform. So it's great tech they acquired. Obviously, one of the things that always comes into play is how do you bring all that tech together and how does it work and when do you offer this and does it get confusing and so forth. And they did a good job when they integrated BrainSpace. So we'll see how they do with these two companies. But it's certainly kind of an indication of, I think, where we're going to continue to see many more acquisitions that come down the pike here in the next couple of years or so.
Deals are back, baby, I guess. I mean, after what seemed like a dry period, we're seeing some pretty big deals happening lately.
Yeah, last year, so Rob Robinson, of course, he tracks all the deals in eDiscovery, which is a great resource. And I think the year before last, 2021, was a record year in terms of the deals he tracked. Last year was about a fourth of those deals, so it was a real drop off. And this year, I think it's much more back towards 2021 numbers. And I'm not surprised. I think the market conditions are right for companies to be acquired, and I think investors are starting to pull the trigger more. They've been working on these deals for a while, and sometimes you get that kind of ebb and flow because they work on deals for a while, then a bunch of them hit all at once. So we'll see.
Did you get?
I think that's
Yeah.
Oh, I was going to say, I think that's a logical explanation of what's happening. I'm going to try to work in all the companies here before this segment's over.
Where's your gong?
You are an iPro, Joe.
iPro. Yeah, and I truly, I think it'll be interesting to see. One of the things that I keep getting the question on is, does that mean the industry is truly consolidating now? But even though there's probably a handful of really large players, there's still plenty of other companies out there, and we're getting new entries into the market. Like companies like Ultimatum and Beagle, with Gen AI type eDiscovery capabilities and so forth. So every time it seems we see a couple of companies get acquired, we get a couple of new entries into the market. A couple of years ago, somebody asked me to do a kind of an analysis of the market, and I counted no less than 50 review platforms out there. And there's, as far as I know, pretty much all of them are still in play today. So yeah, it's not a consolidated market by any means.
There was a kind of a weird. It's kind of weird about how this whole thing was rolled out. I think. I'm not sure about all of you, but I got the press release at I don't know, it was very late on the day, on the day before they were lifting the embargo on the news. So and they weren't offering anybody up to speak to. I've gotten to know Andy Wilson at Logikcull pretty well over the years, and I tried emailing him without any success. And so, I mean, we all, a bunch of us, at least all reported the news the next morning, and then immediately comes the news of layoffs at iPro. And it's kind of, initially I started getting a couple of messages from people saying, you ought to look into layoffs or letting everybody go. And, initially I heard things like half of everybody at iPro is being let go. And then there's it started popping up on LinkedIn and on, there's an eDiscovery group on Reddit where there were some people talking about all this. But
wait, so they're getting rid of half of iPro. So you're saying they only wanted the IP
or the RO?
That's actually a substantive claim. That would they? Oh, okay.
Yeah. Well, they weren't, as it turns out. I mean, there was this weird thing where people reporting 158 number based on somebody having found the WARN Act filing, which said 158 people were being let go. And then I reached back out to the Reveal PR person, basically, who said, no, it's only 79, not only, but 79. And that there was a clerical error, and it was just all this sort of confusion about what was going on. Then apparently there were the other thing that was being said was there were actually layoffs at Logikcull before the deal closed or was announced, so it might have been even more than that. But it's very strange. I mean, that part of it was handled kind of oddly, I thought.
Yeah. Well, there's never really any good way to handle layoffs. I mean, when you think about it.
Yeah.
Mike, I noticed in the chat, Mike, you interviewed Wendell today, and he said that the total valuation of the company is $1 billion. So maybe that straightens that out. But yeah, that's one of the things. Obviously, I've talked to a couple of people who were laid off. I haven't gotten any numbers. I did see, Bob, your follow up where they said 79. I did note that that 158 happens to be exactly twice 79. So maybe there's something in there. Regardless, it's unfortunate for those people, and we're seeing a lot of layoffs for companies being acquired or not being acquired. So, and it's almost always inevitable there's going to be some layoffs with an acquisition. You don't need three sets of accountants. You don't need 3 sets of HR people. It's unfortunate, but it is business.
Yeah. No, I understand that, and yeah, it's going to happen. Yeah, thanks to Mike Corraro for that clarification, because I've seen it all over the place on that. Anything else on Reveal before we move on? Well, while we're on the topic of eDiscovery, Victor, you've got a story involving blobs of indecipherable data.
And America's mayor. So yeah, there's that. Yeah, I like to clarify that during the entire time I lived in New York, I never voted for him. So then again, I think I only had like one opportunity to vote for him. That was like, so but anyway, yeah, so basically Rudy Giuliani had another interesting week. I feel like they all have it. They like, you could say they've had interesting weeks for like years now. But yeah, he got sanctioned for providing blobs of indecipherable data and few documents in Discovery, and basically he defaulted on his on the defamation case that was brought against him by those 2 poll workers in Georgia, and he got sanctioned by the judge in that case. He had his business had to pay more than $43,000 for Discovery violations, and he had previously been ordered to pay an additional $89,000, so total of $132,000 in sanctions. Luckily, because he defaulted, he doesn't get the adverse inference, so there's that. So I guess there is a silver lining in all this. But it's just kind of like, I mean, the whole strategy that he seemed to have was just, I'll concede to their points. I'm not going to contest their points, so that therefore we can't go to Discovery, which makes you wonder what's he hiding, or what doesn't he want to get out there that he's willing to take this default judgment, from these 2 plaintiffs. But I guess we'll we're not going to find out, or we will at some point. But yeah, it just kind of one of those things where, once again with eDiscovery, it's kind of like with all the mountains and mountains of electronic evidence out there now. I think it probably looks pretty suspicious if someone just turns over just a little bit of evidence that just like a few documents here and there that there's no chance that could cover like anything close to like what is relevant in a certain case. And also considering Giuliani's status as a what is it? He's a cybersecurity expert who also ran a consulting company for electronic data and stuff like that. It's also doubly ironic, I guess, in this sense. But yeah, I mean, just it's one of those things where it's just like, sometimes you don't want that stuff to get out, and you pay the price. And I guess he's willing to pay the price in this case. to to prevent that stuff from coming out.
I'm convinced a lot of these guys are just going to go the Tom Girardi route and get themselves declared incompetent before, the shit hits the fan. I mean, I don't know. It just seems like they don't seem to care what's happening. At least some of them should understand the legal implications. So I think that I wouldn't be surprised if you saw one or two of them pull that, but I could be wrong.
When I saw blobs of indecipherable data from the judge, all I could think about was whether they were somehow trying to do some data collection from his forehead and his face, because I seem to remember some blobs of indecipherable stuff running down in a famous picture.
Yeah, of all the stuff that's come out about him in the last year, I have to say this is actually probably the least disturbing thing. Look, a garden variety eDiscovery violation is much better than some of the other stuff that's come out, and we'll leave it at that.
There's a tweet that's going viral. I can't remember exactly what it is, but it's some dad explaining a conversation with his son where he goes like, it's a transcript. It's like me. The weird thing is Giuliani really rose to prominence after 9/11. And then the next thing is son born in 2006. Oh, like he was behind that too? And me, no. But now I see how you would get there based on what you know.
Actually, he rose to prominence prosecuting Gotti, didn't he?
Yeah. Well, he used RICO.
Well, to the law nerds.
Yeah, I mean, definitely. Well, it's funny because I remember there was an editorial in the New York Times the week before 9/11, and they were referring to him as like being like in this operatic controversy, because I think he had announced that he has left his wife on a press conference. I mean, he had done
before he told
really
her
despicable things.
Yeah. Well, no, and I think Joe could probably attest to this, but like living in New York at the time, like before 9/11 hit, people were tired of him. Like it was just so much drama. Like every day, it was like kind of because as like Trump in a lot of ways, it's like, oh, Rudy Giuliani announced at a press conference he's leaving his wife and doesn't tell her, but didn't tell her beforehand. Rudy Giuliani, is he going to challenge Hillary Clinton? Is he not going to challenge Hillary Clinton? Is he going to run for governor? Is he going to, now he has, so it's just, and there were all these like ethical scandals as well, and like stuff with him and Carrick, and it was just kind of like, until 9/11 came around, like people were like, just get the heck out. We're done with you. We don't want to deal with your stuff anymore. And then he became America's mayor. So, which look, I mean, credit to him. I mean, you play the hand, you play the cards that you're dealt. He rose to the occasion at that time, and he did what he needed to do. But since his career since then has sort of been very, very puzzling for a lot of people who watched him in action, during that time period.
I do have just to take it back to the eDiscovery angle. I'm so, I don't know if the judge, I haven't read what it, I don't know if this was, I guess, an opinion from the judge, but I'm curious as heck as to what blobs of indecipherable data actually were. Like, what was he like giving them spreadsheets with numbers that were not labeled or something? Or I have no idea what that could even be. Anyway.
I haven't gotten through the whole. I've got a copy of the order. I haven't gotten through it all yet. But it's really hard to get terminating sanctions. You really, since the 2015 rules changes, you really have to do. You really have to do a lot of things from a discovery standpoint to get to that point. So, obviously he did that, and it's amazing some of the things in the cases we cover that people or companies do, and they're still given maybe an adverse inference at best, and even they're not maybe even a mandatory one, but a permissive one. So you just never know. So it really takes a lot of work to get that terminating sanction.
Yeah. Well, on a related note, I mean, it's not really a legal tech story, but the news this week that the Trump trial in Georgia is going to be live streamed kind of struck a chord for me, because I'm old enough to remember that when live streaming was never ever a thing for trials, and
Court TV.
Well, Court TV.
Everybody's going to become Court TV.
I'm old enough to remember when Court TV started,
Yeah.
And way back when.
Yeah, I watched the OJ trial, like when it was, when it
right,
was.
The OJ trial, and I mean, it's both disturbing to anticipate the streaming of that. As my wife said yesterday, I guess nobody will be doing anything for as long as that takes. But it's also fascinating to think about the ability of that, and how rare it still is for courts to really be openly broadcasting and streaming their court proceedings. I'm glad the court's doing it in this case, but it's still something that a lot of courts are resistant to do. Most notably the SCOTUS, but at all levels. And I mean, a lot of our state court trials, I know in Massachusetts, we certainly allow cameras in the courtroom in most cases, but the streaming is still something that only happens very rarely. And I think it's kudos to the court for doing it in that case, I think.
Yeah, so this is a preview and a plug then for anyone going to Relativity Fest. You can see me, our usual panelists, Stephanie Wilkins, and occasional panelist Isha Morante are doing a panel on that on cameras in the courtroom. So
Awesome.
you can
Yeah.
hear more about it there.
I mean,
It'll be interesting because I mean, I think,
Go ahead.
sorry, go ahead.
No, it's all right. Go on.
Well, I think it's interesting because, like, and we talked about this on the show. It's kind of like, for most, like, I mean, I'm sure, there'll be all kinds of people tuning in, and they'll probably have to, like, set up like a bunch of like alternate streams and like increase their capacity and whatnot and server space and all that nonsense. But like, I think most people are kind of conditioned to kind of think like for that Perry Mason moment, or like that big dramatic moment where you could be, oh, we caught you, and it's like, but most trials are just like, very pedantic, very kind of boring to most. I mean, even to me, like when I'm watching them on the proceedings and stuff. So it's just, I think it'll be interesting to see just how long it kind of captures people's attention, because it's not like, at least with OJ, there was the murder. There was the murder. There was all the fireworks over the Mark Furman tapes and stuff like that, and the gloves. But this is going to be like very like esoteric stuff about like voting machines and like like stuff involving like the fake electors and stuff. I just wonder. I wonder how much like people how it's going to hold people's attentions for that long. But I could be wrong.
Yeah.
I mean, historically, the issue has, I mean, y'all know this, but the issue's been from a criminal defense standpoint. It's, and this is a criminal trial. Correct me if I'm wrong. Like I may be
It's criminal. Yeah. This is
thinking about the wrong thing, but okay.
No.
I was just about to look it up to make sure, but it's a problem because what it does is it causes everybody to behave differently because the camera's there. I think that that's an issue for two reasons. First of all, just from the constitutional aspect of defending a criminal case and protecting the rights of the defendant. Much as I hate to talk about protecting the rights of Trump as the defendant, as a criminal defense attorney, you've got to, like, you have an obligation to represent this person no matter how they come to you and who they are. That's your job. And it really can affect the course of the trial. So I think that that's problematic. And then the other part that's problematic is who knows what his antics are going to be, less for the purposes of the criminal trial and more just for the purposes of dog whistling at his followers. I mean, I just think it's a weird decision in this particular case to do this. And at this point, I don't think Donald's able to find a lot of very competent criminal defense lawyers, so maybe they don't even care. I don't know, but I think it can really hamper the defense of somebody when you got the cameras there.
And will Democratic candidates need equal time?
Right.
Right?
Well, Bob Menendez might be getting equal time. Anyway, but it's interesting, the point about protecting the defendant, because I actually feel like, we talked about the OJ there. I always thought that part of what helped OJ was the fact that everyone wanted to see a confess on the stand like Perry Mason moment. And as it became more and more tedious, people were more like, well, really? I don't know. And I think that's an issue, not just with the audience at home, but it's because there's kind of a civics literacy problem with jurors too. The jurors expect it to look like that because we don't see these things on TV ever. And you get a bunch of people in there and they like want to see a slam bang kind of show like Law and Order. And then it's a bunch of incredibly boring nerds talking for 4 days. And then they think, well, I guess they didn't have anything.
And if we didn't have the OJ trial, would we have ever had the Kardashians?
No. And yeah, God damn it, OJ.
uh, all right. Well, let's see. Going back to some actual legal tech topics. I mean, that's sort of a legal tech topic because streaming courts and all that. But uh, Jean, you were something. You have a story, not that you wrote this week, but in which you were written about.
Yeah, Aisha from ALM Law.com wrote a story where she interviewed me and another attorney about now the story is about the concentration, the power concentration, the duopoly, the famous duopoly, Lexis and Westlaw. And it's interesting because she sort of focused on the concentration where Fastcase has been bought, and who knows what their future is. Taste Text has been bought by TR, and just that there are fewer lower cost alternatives in the marketplace. And what I tried to bring up is there has been, I actually, and this is probably viewed as somewhat controversial because Ron Friedman, who I have a lot of respect for, completely disagreed with me on this. I actually see a number of factors contributing to the research platforms, Lexis and Westlaw, going the way of Blockbuster Video, because there's going to be, well, first of all of the primary law is already commoditized. And I believe that AI is going to make the secondary law, which young lawyers are interested in, which is practical guidance, that is easily going to become, AI is going to make that a commodity. And treatises, which were one of the things that lawyers, that people kept Lexis and West Publishing for, where's the generation of lawyers who care about treatises? There's the boomers, and I think the millennials who were trained by the boomers, and after that, I don't know that anyone is going to care about legal treatises 20 years from now. I'm not saying that's a good thing. I'm just saying there is absolutely a decline in reliance on certain kinds of secondary source material that has sort of kept, which has sort of secured the Lexis and Westlaw dominance. And I just think there are a number of things, it's like the perfect storm. There are a number of things brewing, and I'm not saying that Thomson Reuters or LexisNexis are going to go out of business, because very smartly, they have diversified. They are in the software business, they're in the risk business, but I seriously wonder how much longer they are going to get away with what they have done to price their online research the way they priced it. And again, built into it, they have never given up the assumption that it's not the law firms, it's the clients that are paying for that. And ever since 2008, clients have been saying no. So it's become more and more of overhead. And so firms are paying for those systems entirely, and often they're paying for both of those systems. And plus, in general, and this is more true for Thomson, customer service has declined. So it's sort of like you're paying white glove prices, but you're being completely disrespected and ignored as a customer. I have to say, I feel like that firms are treated like cash machines. So I guess I have strong feelings about this. So anybody else want to comment?
Well, in terms of first of all, I thought what you said both just now and in the article was spot on about the white glove prices and not getting white glove treatment. And that's something that's got to break at some point. It's got to give. But then the other thing that you mentioned about treatises sort of falling out of favor. And I think in addition to the younger generation not relying on them as much, as someone who wrote a treatise, co-authored a treatise for a decade for Thomson Reuters, let me tell you, they don't pay a lot and it's a lot of work. And I think that people they're really kind of struggling, because I've had people reach out to me since wanting to see if I'd write this treatise or that treatise. And they're having a hard time finding people willing to write them for these lowball prices that they are offering. So I think that might be another contributing factor to sort of the decline of the legal treatises that we all grew up on and learned how to practice law using.
Actually, the other day, Bob actually made a point on this topic. Bob had said, Bob said that
conversation.
yeah, Bob made a point on this that because Niki and I were having this same conversation the other day, and Bob kind of said, well, if there is a role where AI could crunch all of this information and spit out a treatise-like answer, that will still be something that needs to be kind of guided by the human treatise, the corpus of, like learned thought that these two companies have right now, because that's what's going to have to train an AI to look at everything and figure out what is good and bad. But I do think over the long haul, that does start fading away. And over time, AI is going to be able to just like spit out, here's the answer, the treatise-y answer.
Never discuss weighty topics after a few glasses of wine at Deltacon, but we were talking about this sort of kind of this very
talking
topic.
about
because-
We're talking the exact concept.
Yeah. And in part, what we're talking about is the vendors out there that have access to a lot of this data, but not that secondary data, and what kind of what kind of generative what kind of output they can put out there using generative AI. And I'm still of the opinion that clearly that secondary content provides a major advantage to Thomson Reuters and LexisNexis. But I also fully agree that that's the way it is right now, but it's probably not all that far off into the future where the AI gets so good that that secondary stuff is less important. And certainly, to your point about treatises, I mean, I don't know anybody who when's the last time you looked at a treatise on anything? I don't know, but it's sort of gone the way of the law review.
The other value, I think I still think Thomson Reuters and LexisNexis have cornered the market on this generative AI. I think that it's going to put them in a significant competitive advantage across the board, in part because they may not have all the software that has access to all of the law firm's operating systems and business information, but they each have some of it, in addition to all the case law, in addition to the treatises. And so when you can build those bridges across those different data sets, you can provide invaluable information. And they were already doing this before generative AI. Lexis was, at least. I think Thomson Reuters was as well, but I know Lexis was. And that can provide you with invaluable types of information when you can make your law firm's documents, have links back to the relevant parties and cases and references within those documents, even if you didn't put them in there, turn them into live links like a web page. So there's lots of interesting potential. And that's also where the companies that house that data, whether it's document management companies or law practice management companies, also are sitting on some gold mines of data that will provide the customer value. More is what I'm talking about, not data they're going to sell in the market, obviously, but the data that customers can then use with generative AI applied on top of it and provide all sorts of insights and valuable information. But I do think Thomson Reuters and Lexis are kind of uniquely positioned to either be the home base for that or provide bridges in to that.
Well, let me just mention one more thing. BLEX Fastcase is still out there. They are also working with AI, and they are still cheap. So companies like that, lower cost companies who can get a hold of AI, are going to have a lot more power to disrupt at least the financial basis that Lexis and a lot of the financial assumptions that Lexis and Westlaw have been able to get away with for the past 20 years.
And there's got to be new players coming along. I mean, I think we've seen this several times over the history of the legal tech world. Is where there needs to be products that serve all segments of the market. And I was wondering the same thing actually, going back to the Reveal acquisition of Logikcull. I mean, Logikcull was one of the few eDiscovery platforms out there that really kind of focuses on the smaller firm end of the market, and there are very few tools available for small firm. There's some other stuff out there, but very few. And who knows what what Reveal is saying is they're going to keep it. They now want to span the market from small firms all the way up to the biggest organizations. But hopefully they do that. But if not, something else is going to come along to serve that part of the market in eDiscovery, and something else going to come along in legal research, I think.
Okay, Jason from Bloomberg just chimed in something. What? Oh,
Bloomberg
he
AI
doesn't tell us what his point is.
Yeah, but
Tell us
you know,
more, Jason.
yeah,
Well, there are other, Bloomberg's one of the other, and when I've written about AI in the past, I do talk about how, Bloomberg, in addition to Thomson Reuters and, a few other companies, own a lot of that data that provides the court analytics. It's not just Thomson Reuters or Lexis. There are a few other, there's a fourth one that is evading me right now, but that also owns a lot of proprietary data and has AI that helps pull analytics out of it. I can't remember who it is.
Volker's
Trellis? I think it's Trellis.
Kluwer, Bloomberg,
I know it's Bloomberg. I might have been
and
Walter.
Volker's
Kluwer, I
Kluwer.
don't think so. I'm not sure, but anyway, I think that there are other companies that also have the ability to do that as well. So it'll be interesting. I think there's going to be a bit of a battle out there, and we'll see what happens when the dust settles.
Yeah, one other trend that could impact all of this is the increasing deployment of kind of retrieval augmented generation with generative AI tools, and the examples of what companies like Net Documents and others are doing, where essentially a law firm's own knowledge base becomes the body of knowledge against which the AI is able to provide its answers. And to some extent, if you're a large enough firm with a big enough of a knowledge base, then all of those briefs and memos and everything else that have been created within your firm kind of become that secondary content in a sense, and help the AI create new content out of that.
And also become the practical guidance tools. I mean, that's
Yeah.
what KM is all
That's
about.
kind of what I'm saying.
Yeah.
Yeah. All right. No transitions here. Niki, what did you have?
AI, it's AI.
Okay,
so
AI, more AI. Okay, of course. Okay, we can talk about more AI then. Go ahead.
Well, so there was an article that caught my eye. The title in particular was intriguing, but the case itself did not go quite as far as the article suggested. See if I have this. Okay.
I've got the link.
But it nevertheless was, it's an interesting proposition. Okay, you got it there twice. And the article suggested that this California case, that the title had been handed down, basically stood for the idea that AI vendors are liable for biased job screening. That's actually not, it was more of an extrapolation of the holding from that case, but it was still really interesting because essentially what the holding of the case was that the California Fair Employment and Housing Act permits a business entity acting as an agent of an employer to be held directly liable just as the employer is for employment discrimination in violation of the Fair Housing Act in the appropriate circumstances, which has a lot to do with like the size of the business and the number of employees in order for it to fall under that provision of the act. But it was interesting because the thesis of the article essentially was that this ruling has implications for the AI industry, which is true because a lot of organizations, both the companies themselves and also their vendors, that they contract out to screen applicants, job applicants, they use algorithms to target and screen applicants and perform other types of determinations through that process of hiring somebody. And one thing that I've talked about and we've all talked about on this show a lot is the inherent bias built into AI, especially when it comes to people of color and women, and that these tools, and generative AI is equally guilty, if that's the appropriate word of this as well, that these tools really do in multiple ways act make determinations and provide data that is detrimental to people of color and women because of all these built-in biases. And obviously in the context of job hiring, you can see how that can be problematic. And in this particular case, It was someone who had applied for a job, and it was like a health screening after the job acceptance that went into like her personal reproductive health, which seemed really strange. And I think that maybe partly she refused to provide this information, and that's partly what triggered her to seek out, I assume, the services of an attorney. But I just thought it was interesting because one of the things we're all going to be grappling with, well, you know, the legislatures and us as a culture, are how to regulate AI, the impact of AI on our culture, especially because it's advancing so quickly. So it'll be interesting just to see how these types of things kind of play out as AI becomes subject to these types of holdings, or are they going to issue different holdings and treat the AI differently? I don't know. It's hard to tell. So I thought it was an interesting case.
Yeah, that is interesting. Didn't New York City's didn't they pass a law that employment screening algorithms have to go through a bias audit? Didn't that? I think I remember that coming into effect. So I think that's the only one I've seen. But to me, that's I wouldn't be surprised to see more of those, especially if cases like this come up, because that certainly seems like you know, we see so many biases in algorithms out there for everything from employment to obviously facial recognition's been accused of having biases. You had the compass system for sentencing, you know, that was shown to have some biases. So absolutely, I think we've got a lot to go, a long way to go in regard to that, and some controls to put in place. So I'm hoping this helps push this a little further down that path.
So last year, so for people who haven't followed me enough to know that in addition to all of my jobs at Above the Law, I also am the debate coach at Army. And so my cadets last year, the topic had to deal with AI. And this was actually an issue that we did a lot of research on. There's some fascinating legal scholarship in law reviews, law professor stuff, all that secondary stuff that people aren't reading but should. There's some really interesting scholarship out there about how the only way we can really address these issues over the long haul is we're going to have to sit down and say, this needs to be a mandatory licensing scheme in the way in which, you know, driver's insurance and stuff is. The only way that you can do it, because right now the liability swings back to the people writing the original algorithm. And sometimes that's deterring people from trying to innovate because they don't want to be on the hook for something that isn't their fault because the algorithm didn't discriminate. Somebody pumped it full of garbage data, and the garbage data that they put into it is what went wrong. And there's some law professors who've looked at this and said, this is a perfect condition for insurance pools and distributing risk that way. Mandatory insurance and saying, you know, the person licensing it who wants to shove it with a bunch of property value data has to pay a lot more because that's probably going to introduce bias to it that the original programmer didn't. The original programmer pays less of a rate to blanking on the word. Premium, less of a premium for their coverage because they just put it out, and more for the people who put it. Really interesting stuff. And we had some good evidence about how insurance companies are prepared to make that kind of actuarial decision making, and probably would smooth the path for better innovation long term if you did that.
Well, we're running short on time, so I think it's only logical to ask Joe to reveal the story he was going to talk about this week.
I decided to start making little placards for how good your transitions are there.
What's the most I can score?
10.0, like gymnastics, but am I in
that
mirror?
was like a 7.
Yeah, all right, yeah. Oh,
Yeah,
okay.
that's pretty hard. That's pretty harsh, Joe. Like, what are you, the East German judge or something? Come on.
Yeah, I was gonna say, yeah, all right. So I have a 10.0 printed up too. I was ready for one of those, and then it just didn't happen this episode. The whole time I was like, all right. Anyway, yes. So my only issue this week was I had a an article that I put out because Caroline and I, who sometimes is on this show, theoretically is a panelist, Caroline and I actually had a joint meeting with Zero, and we were chatting about all sorts of stuff that Zero is up to. We didn't really have an agenda, and they do lots of things, but the conversation kind of naturally went down the road of these guidelines that in-house counsel have started dropping on outside counsel over the last few years. It's the bane of outside counsel existence, because in-house, these clients start writing up these arcane Bibles for how to bill them that say, never use the word telephone, only use the word teleconference, like stuff like that, stupid things. And then they use this as ways to drag out the billing process and reject bills because you didn't put everything in 0.05 increments, which we require, yada, yada, yada. And it's really kind of killing productivity. I mean, the in-house people think that it's really helping out because they think that they're getting one over. But in the end of the day, all that happens is people raise their rates to cover the overhead of having to pay staff people to deal with all this garbage. And what Zero has that I thought was really interesting was they're working on stuff that can look at not only an AI answer to look at what the guidelines are and navigate those and look at what the bills, the pre-billing comes in and score it against the actual guidelines, but they can go back into the past history, past bills that have been paid versus haven't been paid versus have been sent back versus how bad that was. Because and what Alex was telling us, CEO of Zero was telling us, was that they did that because they started finding that not surprisingly, some of these arcane rules never get enforced. They're just there so that the client could enforce them the month that they want to drag out the billing cycle a little bit longer. And so it will look at these things and determine these are things that they are known to care about. These are things that they aren't known to care about. So we're going to put a higher priority on that. We're going to try to get it all right, but we'll put a higher priority here. Oh, these situations, sometimes they're vague rules that just say do X, and they make complaints here and there that, oh, well, this isn't what X means. It looks back through your history of billing and goes, no, actually back in September of 2018, you thought that this is what that meant. And it will use that data to correct, even offer suggestions of the correction for the description that should be offered by the lawyer for that amount of time that would then comply. And it offers it to a human and says, this violates these rules. We think this language would satisfy them. And even on that, he said that it's using the past individual lawyer's version of their diary entry and tries to make it sound like that person directly and uses the style that they've used in the past. I thought it was really fascinating. Oh, way to get around. And it's a use of AI that's not going to land you in, sanctions. Like, I don't know, some people we've talked about on this show this year.
Can it hallucinate extra hours?
I know, right? Like, all it's doing is taking the hours are fixed by the humans. It's looking at the hours and it's just like, oh, yeah, you didn't describe what you did in a way that they will accept this. However, we know what you did. We're looking at all this. We're looking at what they've accepted in the past. We suggest you rewrite it this way, and a human in billing can either say yes or no, or then elevate it to the partner if they need to. But yeah, I thought that's a good use of AI. Yeah, in the comments, but yeah.
It is, and then I mean, it's also already happening on the other side of that equation, right? I mean, the in-house clients who are in-house legal departments are already using AI to review these incoming invoices for compliance with their billing guidelines, and if you can cut off any problems before you even send it out, then you're going to get paid faster and have fewer issues, I guess. Any other comments on that? All right. We Doug, we got a couple minutes. I know you've just kind of launched a series of posts you were telling me about earlier that raises some interesting issues, and I know you've just kind of gotten started with it, but maybe you can give us a kind of a preview of that and have you back a little bit later to talk more as you develop this thread. But
Sure. Yeah, so I've had some people reach out to me over the past couple of years about the whole hyperlinked files treated as attachments issue in Discovery. And there was a case a couple of years ago, Nichols v. Noom. They had an ESI protocol where they didn't explicitly say that they should be treated as attachments. So Judge Parker said they shouldn't be. Then we had a case earlier this year, StubHub case, where they specifically, the plaintiffs apparently negotiated a much better protocol for them, where they were said they needed to be treated as attachments. And so again, the judge ruled according to that. Then we had a case a couple of months ago, which was the first one where they were still negotiating the ESI protocol and battling on it. So it's the first instance where the ESI protocol didn't factor into the ruling. And that was the InMeta Pixel healthcare case. And it was a short ruling because the judge was just ruling on a couple of issues and just made a ruling. But she said they shouldn't be treated as modern attachments, but the plaintiff should have the ability to request files on a case-by-case basis, but not as a matter of course. So I kind of started thinking I'd like to start a series writing about that. And so I wrote about the case law, the 3 cases. I also did a search on eDiscovery Assistant and found one case that actually mentioned the phrase modern attachments, which was a case where it was just the ESI protocol order. And they actually, the party agreed, it was the NRA acetaminophen litigation, where they agreed to treat them as modern attachments in the protocol, which now, of course, you know, they've taken on that headache. So it's a good thing they have a lot of acetaminophen because they might need it. But I decided to put that discussion of, you know, whether they should or shouldn't be out on LinkedIn, and got a ton of people weighing in. And it's really about close to 50-50 people who say they should be or shouldn't be treated as modern attachments. But what I found with this initial set of arguments is that some people are straying off topic a little bit, because, you know, I had people say, well, if I have a link to a Wikipedia page, that shouldn't be produced. And of course not, it shouldn't be produced. We're not talking about that. So I'm going to have a series of posts that kind of get into the different issues. I think the next one is going to be an attempt to try to kind of put together some assumptions about what we're talking about, try to hopefully get everybody on the same page. In subsequent posts, I'm looking to do like some pros for treating them as modern attachments, and then some cons, including some of the technical challenges, and then hopefully even look at some of the different technology solutions out there, both from the source solution standpoint, like M365 and Google Drive, as well as products out there that are supposed to help facilitate retrieving those links. So I'm not really sure where it's going to go, but I've got obviously a lot of interest and a lot of people who have strong opinions one way or the other. So I'm just going to kind of continue to hit different angles on the topic and just see where it goes.
very interesting. Good. All right. Well, we've got a couple minutes. Any good of the order, or shall we start our Labor Day weekend now? Joe, did you have something to say? You looked like.
No, I was just going to remind people to sign up for skills.
I'm waiting for Joe to offer
Yeah.
like another use of one of the eDiscovery company's names. I feel like you didn't do that as much as you promised. I was waiting for lots of like. give me another
No,
one.
I got in I got
Reveal?
reveal, and I got IPRO with the IP joke and
Logical.
slash serious comment, and I got the logical, and I got everyone in that deal.
Oh, I thought you were gonna like pepper in some other ones. I was excited to see what you did. 'Cause I can't do that kind of thing. It doesn't work for me.
All right, Kay, one of the things I was going to say. I did. I got the last one.
There's a 10. All right. Yeah. Yeah, and just to follow up what Gene just said, O's posted in the chat here, but he's got a conference coming up. It's not until January, the conference, I think, if I have the date right, but the registration closes for it pretty soon. I've heard it's a great conference. I haven't been to it. Have you been to it, Gene?
It's a great conference. Yeah, I've been going for years. It's
Yeah.
now mostly virtual, but it's terrific.
Yeah, good. And I know I think O's is also a speaker at there's so many conferences in October, but one of the ones is KM and Innovation that Patrick DiDomenico and Joshua Fireman are putting on in New York. I am a media sponsor of it for whatever that means. And I'm going to be there live on site recording a bunch of podcasts. So that will be a good one. All right. Well, everybody have a great Labor Day weekend. And we will see you back next week. And I hope everybody, thanks for that link to the skills conference in the chat. And I hope to see everybody here on September 15th for a big gala 100th episode celebration. Not sure exactly what we're going to do that day, but we're going to do something. All right. See you all then. Have a good weekend.
Bye, everybody.
Well.
Stay safe.